Okay, morning everyone. Let's make a start. So, last week we finished off briefly introducing duress. And duress is the idea that you are coerced into entering into a contract, right? And it's what we call a vitiating factor. It says that if you are coerced into a contract, then you have the right to have that contract declared void. In other words, it doesn't exist. Okay? Now, pharmacy care sets out what we say are 7 steps, or rather these are 7 descriptors of the duress process. They really can be boiled down into 3 broad categories, right? One is the nature of the threat, principles 1 and 2, whether they were coerced by the threat, principles 3 to 5, and then what's the effect, okay? So as I said last week, the material is sort of there, so I'm not going to go through it in detail. I'm going to give you the roadmap to then apply it to fact scenarios that you would potentially encounter as to duress, undue influence, and unconscionability. So before I do that, just by way of kind of reintroduction, these 3 areas often overlap, right? And so remember, let's go back to cancellation. Remember with cancellation, you had the 4 grounds of cancellation, right? And repudiation can sometimes be breach, etc. You know how like they can be that overlap? And you would list the different grounds sort of to reason in the alternative. Well, it's the same principle with these 3 vitiating factors. It's the idea that that a certain fact pattern may give rise to these different causes of action. It's perfectly fine, perfectly normal. It's part of your training as a lawyer to be able to reason in the alternative. So if you see something that you think enlivens both 1, 2, or 3 of these grounds, then just go through them all, list the strongest one, obviously, that put your strongest foot forward, and probably spend the most time and space on that, but still use the other 2 as well. Now, the other 2 have slightly different requirements, and so that's what we'll go through, but just highlighting that there's often a lot of overlap. Okay, so really what you want to be focusing on with duress is the threat, right? The coercion, and then the effect. Okay, it's really the 3 things, and that they sort of walk along the timeline. Okay, so we'll go through this. If you have any questions, just let me know. But that's kind of the broad roadmap. Now that first step, right, the threat, or the first element, is about assessing, is this the kind of threat that is improper? Is it inappropriate? Or is it just par for course in contracting? Because when you enter into a contract with someone, there is always pressure on either side. Okay? Just because you feel pressure does not mean that is inappropriate or improper pressure. You may even feel stressed, you may be sweating, you all of those things, but that doesn't necessarily mean that it's improper pressure occasioning a defense or claim of duress on your part. Okay? That's important. So there are some examples here. A threat to report a person for a crime has been held to be improper, and all of these are threats which are used to influence someone to enter a contract. So if you say, you got to sell me your house because otherwise I'm going to report this crime that you did, that may well be grounds for duress. Okay? A threat to prosecute someone may well be illegitimate as well, and a lot of these are circumstantial. So sometimes a statement, as we'll see in the McKenzie case actually, a sometimes a statement in one instance may be considered a threat, and sometimes it may be just part of business. Often it's a flip of the coin. So you don't have to be too worried about, oh, did I reach the wrong conclusion? It's more like ask yourself, is there something improper, inappropriate about this threat or this negotiating tactic, right? Also, potentially the threat to not complete the building of something unless the purchaser agrees to a 10% price increase. Now, this is probably a quite common negotiating issue. In New Zealand, we have a lot of our economy is tied up in construction and development of property, land, right? Developments. Who has seen around where you live, like those big townhouses going up? They tear down a single section house and then build like 5 apartments. Yeah, so that's kind of a lot of what our economy is built on. And so in what this North Ocean case seems to tell us is that in some instances it may well be inappropriate to sort of hold the purchaser to ransom by refusing to complete the job without a price increase. That may well be different if you can say that the price increase is, a legitimate factor in the materials have gone up, labor costs have gone up, whatever, right? So that then again, there's some nuance to that. But if you're doing that in just a way to sort of nakedly get more of a windfall benefit, then yeah, that may not pass the sniff test. Okay, which is kind of what was what that Williams point is about. So. Is the threat improper, or is it something that you can justify in the course of that particular context of negotiating contracts? Okay? And that will be up to you to argue on the facts. So you're asking proper or improper? Right, then we get to the coercion step, okay, or the inducement step. And this is the idea that the threat and the threat and the entry into the contract must have a causal link, okay? So the threat to the contract entry, you must establish this link, okay? Now, it doesn't have to be the only reason. Importantly, there could be other reasons plausibly why this person entered the contract, but all you have to show is, was it a significant cause of the plaintiff's assent to the contract? Now, you can use those cases as authority. You don't have to go into them because they're not on the reading list, but they're just authority, and it's up to you to argue on the facts. Do you think there's a significant cause or significant causal link between the threat and the coercion? So that's really what this step is about, okay? Establishing that there was a causal link, a significant causal link. Okay. Then if you establish those two, what you have is duress, okay? And there's just a bit of a clarification as to two things, right? One is the meaning of the word voidable, which is what the law says that the contract is. It's not on the face of it like void. What this means is the legal rights exist until under the contract exist until the person applies to court to have it declared void or raises it as a defense. Okay, and there's a public policy justification in this power on case, right? It basically is about certainty. That's what the extract is telling us. It's saying that we can't create the uncertainty that someone would claim their contract is void and someone would claim the contract is not. Right? We can't create an uncertainty as to the status of the contract. We must wait for the court to adjudicate the status of the contract when somebody brings a claim of duress or a defense of duress. Then and only then will the contract be declared to have not existed. Okay? And that's why the court there says duress does no more than confer on the victim the opportunity, if taken in time, to avoid the contract. And so the implication which I put on the second dot point there is the contract remains on foot until the victim, the one claiming the contract is void, puts the other party in the position they would have been if the contract had never been made, which is the default position when seeking to rescind or have a contract declared as non-existent, right? Because logically, if you go back to the timeline, right? If you're going back to this point, then all the rights and obligations of the property ownership are here, and money, right? So if you want to have the contract declared void, you got to be able to return everything that you got, and they have to be able to return everything that they got under the contract. Okay? So the court says that's designed to create certainty so that until we say the contract is void, then it stays on foot and can be enforced. So that will then allow if the perpetrator of the duress tries to enforce the contract, then the other one can raise a defense of duress. Okay, then it will come before the court. Now, there is a residual uncertainty which I'm fine for you to leave as a residual uncertainty in the law. Okay? Teaching you that uncertainty is fine. It's normal, part of the law. Could be resolved in future cases, we don't know. But the residual uncertainty is what happens if the victim can't do this? Does that stop them from being able to use the duress defense to have the contract declared void? That is, they can't return or restore what they received under the contract, even though it was procured by duress against them. Okay? So the court in Halpern and Halpern suggests that in principle, they agree that, look, if you want to have the contract declared void, you need to make restitution. You need to give them back what you earned under the contract. But they say, if it would be surprising if the law could not provide a suitable remedy if that were not the case. Okay? And they declined to provide an indication of what that remedy could be. They were just like, there's got to be something. There's got to be some way that the duress cause of action or duress or defense can still give relief to a claimant, even if they can't necessarily make restitution, the specific restitution necessary to bring the parties back to this point before execution. Okay? One example then the court gave at page 483 was to say someone persuaded by improper means to pay an excessive amount for work done on his house, for example, retiling of his roof. It is hard to see why it should matter whether the improper means was a threat or fraudulent misrepresentation. So let's just say it's a threat. Okay, that's duress. In either case, one would expect the law to find a means to enable him to recover his money, that is, what he spent on the job, without requiring him to undo the work to the roof. It may be open to debate whether he should be required to give any credit for the value of the work done, assuming it was of value to him, but there could be no justification for any such counter-restitutionary requirement if the evidence was that the retiling had not in fact been needed. Okay? So what is this telling us? It's saying that if you have that situation where the tiler has strong-armed the owner of the house into allowing him to retile the roof, or allowing her to retile the roof, okay? saying, look, I'm going to tell your wife you've been having an affair, or something like that, right? Like that's duress. Like that's a threat. That's improper, right? And so the person's like, okay, I'll pay you to do this job. And then midway through the job, right, the roof is about half done. Then the Tyler tries to enforce the contract of payment. The owner of the house disputes this. It goes to court. Owner of the house raises duress as a defense. Court says the contract is to be declared void. Which means that the owner of the house should get their money back, right? That's restitution. Okay, they should be able to get their money back. But what about here? What about all the work that the Tyler has done? What the court in Halpern is saying is, it's got to be possible for this restitution to be required, right? The house owner's money, but not this restitution, right? And it seems to be that what the court is getting at is it's impracticable. It's impractical to require that person to rip out their roof and put back the old roof. Like, that's just not going to happen. Okay? Now, should they get a benefit of a half-tiled roof, or the benefit of the work that's been done? The court leaves it open. The court says, well, maybe we can do like a partial return, like a credit kind of thing, but we're not going to tell you what that is. So, what does this mean for our purposes? We start by saying that if you want to have your contract declared void under the doctrine of duress, you must be ready to return everything that you got under the contract, so that the parties can be put in the position they would have been before the contract had been entered into. Okay, that's restitution. We want to return the parties back to this point. So that's the starting point. But if it's impractical to do that, or the court otherwise doesn't consider it appropriate to be made, right? That appropriate for that restitution to be made, then it's possible that this restitutionary requirement may be removed in part or in full. But that remains a gray area. We don't know whether or to what extent that will be enlivened. So we just have to say, we start with the requirement for restitution, but we then say it's ultimately the court may create an exception to that. Okay? And you may be thinking, well, if it's not the law, why do I have to know it? Well, the point is that it may well be the law. We don't know. And so part of being a good lawyer is being able to persuade the court and to tell your client where the law can or should go in the future. So that's part of being a good lawyer. Okay? So that's what I'm trying to train you to think about, where the law could develop. And so this is an area of residual uncertainty that we don't know where the law will develop, but we have to wait to see. And lastly, right, so your effect is, number one, restitution, right? So the effect is the contract's declared void, parties put back in their position, restitution, and then you ask, is affirmation a factor? If affirmation is not a factor, then that's fine. Affirmation would only be a factor if at some point along the contract line there had been a point of free will. Okay? At the point of free will, did they decide to move forward with the contract, or did they not? Quite similar to the affirmation analysis we have done under cancellation. Okay? So a couple of examples. Haynes and Carter involved a relationship separation agreement. A couple separated and they had a settlement agreement about who got what. And one party, started acting under that agreement, took steps under the agreement as required, and then later tried to claim duress. And the court said, so they failed to make payments, and the court said that's you saying you want to go ahead with the contract, right? You've moved ahead under the contract, and you've made a decision to do that. Now that may well be different if the duress was ongoing. Okay, so really we want to ask: is the duress ongoing, or is the duress, has it stopped in a way? Because in that situation, let's just say one party is, holding one of the children hostage or something like that, and keeps holding the children hostage. Well, logically, then any assent to the contract and then any behavior to action the contract, that's not going to be held as affirmation, right? It's still under the banner of the duress. So it seems to be that courts will say, when you have a decision to make, did you make that decision, or have you at a reasonable opportunity, have you tried to get out of this arrangement? That seems to be what the court is getting at. But pharmacy care tells us, similar to cancellation in a way, that you need to do that within a reasonable time. So you won't have all the time in the world, right, to make that decision. So here's reasonable time, right? And after that point, it'll be affirmed. So that's what pharmacy care says, okay? Now, pharmacy care involved an allegation of criminal proceedings, a threat of criminal proceedings by a government agency, I believe, or the prosecutor's office, on the basis of like a failure to comply with some medicine requirements, right? And so that was kind of an out of an audit issue, and there was an agreement reached, but pharmacy care then alleged that it was procured by duress, okay, which led them to settle with the government agency. It's quite common, that we will do all these things in compliance if you don't prosecute us, right? And so they later say, well, actually, do you know what? That was procured by duress. We want that declared void. We don't want to have these. We want to contest the charges if you're going to bring any. Bring them, but we're not going to submit ourselves to this ludicrous settlement deed. Is kind of the approach. And they then say that they bring that argument, and the court says, well, you waited 3.5 years, to bring the proceedings, to set that settlement deed aside. So independently of whether or not it was procured by duress in the first place, okay? The fact you waited that long is an indicator that you have affirmed the contract. Now, that is not so much an analysis that expressly talks about the free will point, right? It's more an overall assessment. It's to say that, look, there's no reasonable way that you could have waited that, you needed to wait that long, right? The effect of the duress did not extend that long to justify you bringing it only after 3.5 years. Okay, at some point you had a decision to make and you didn't make it. Okay, and we can infer from your inaction that you wanted to go ahead with the contract. So it can be inferred by the court. Okay. So that's really the that's really the tension, because am I saying that every 3.5 year delay is going to automatically preclude a duress action? No. 3.5 years could be perfectly legitimate to bring a duress claim if you've been living under a particular threat, particular circumstances, right? So you have to argue in any particular fact situation, why do you think that them waiting that long was justifiable or not? Okay, and that is a matter on the facts for you to argue. Did they have free will? And did they decide to continue with the contract out of that free will? Okay? And I should say that seems to be the thread that's running through these cases. By the way, the courts are not going to say that, but I'm giving you the kind of the roadmap or the sort of the mental approach. You should always defer to the cases, but that seems to be the thread, the way to understand affirmation. Okay. All right, I'm not going to go through McIntyre because you can read that, but now when you've got the roadmap, you can read and understand what happened here. I'll very briefly give you what happened, and then you can go back and read it if you haven't, okay? So here what you have is a subdivision agreement, again, very common in New Zealand, and it was the agreement at issue was between the developer and the project manager, the one who's going to arrange the development, right? The project is aimed for 3 years, takes 11 years. Again, not uncommon. There were variation agreements about the project manager's payments, right? So they varied his employment agreement or his contracting agreement. And the allegation was that he had made various threats or acted in a way that coerced the trustees who are in charge of the development to vary the contracts as to how much he would be paid. So he had essentially held them to ransom. It seems to be the argument. Okay, so McIntyre is where we see this developed approach taken. Okay, the Court of Appeal says, do you know what? There's sort of three things: one, the threat; two, the coercion; and three, the effect. Variation, affirmation. So that's really where I got this three-part summary of what pharmacy care was going towards. Okay? So they looked at the entirety of the relationship and they said, you know what, we can't find a threat. Okay? Because the relationship had obviously deteriorated, and he'd obviously made several strong statements about the continuation of the development, right? He'd sort of said, look, if I'm not paid more, this is not going ahead. But the court could not construe that as a threat, okay? And the court said it was not necessarily illegitimate for him to try and change the terms of management, and the minutes of the trustee meetings, right, or the sort of records of the trustee sort of deliberations, none of them indicated that there were threats or pressure made. There's a sidebar here, right? Just in terms of practice, because I think it's important. This case reveals the importance of documentary evidence. Okay, contemporaneous documentary evidence. Because courts will look at the documents and say, well, let's try and infer a solution based on what we can assess as the documents. Okay? And part of that is, in terms of legal practice, get into the practice of whenever you call a client, right, immediately take a file note, write down when you took that file note, like date and time. If you want to sign it, but date and time is sufficient, and that will be logged. And so that's a detail of what you said to the client at the time. Okay, that's a contemporaneous record. Similarly, when you have meetings with clients, do the same, right? Because what that's doing is building in your practice the ability to then much later on, if someone says something, you can be like, no, we met at 1:52 p.m. at this time. I called you at 1:57 p.m. I said this, you said that. Okay, so that's just a tip for practice. I think that's one of the most useful things that I learned as a lawyer, the practice of contemporaneous documentation. I think that's something that will really help you. And these kinds of disputes bear that out. They look at the contemporaneous documentation. So here, going back to the case, they couldn't find any evidence that had been interpreted as a threat. They did say it was reprehensible, right? So he clearly behaved abhorrently towards the trustees. Okay, he had expressed his grievances in a quite inappropriate way, and when you read the case, you'll sort of see that, right? And he had threatened in a way, right? But the court was like, look, do you know what? This is this is not outside the realm of a commercial negotiation, but they did say it was a finely balanced conclusion. And what this means is this, that if you had the same fact scenario and you reached a different conclusion, that's perfectly fine. Okay, that is normal. You would just need to justify and argue why you think that it was an improper threat. Okay, why you think this was outside the bounds of normal negotiations or normal commercial practice in this particular instance with regard to all the facts. Okay, that's all I would expect. And then very briefly, compulsion and coercion. They looked at, again, the documentation, and they were like, no, the trustees here did not choose the variations to change the terms of payment, etc., because they were the only option available. They chose them because they decided this was the best way to move the development forward. Okay, they weren't coerced, they made this decision, and they weren't unduly or inappropriately pushed by whatever this guy said. There was no coercion. And they said, look, let's discuss affirmation anyway. Even though we found that there's no threat, no coercion, let's just discuss it anyway. And the courts are actually quite helpful sometimes in this regard. They give us reasoning in the abstract. So they said, look, even if there were coercion, and even if it was a threat, the trustees kept paying him the increased amounts, and they didn't raise the issue until after he had died, and this matter was handled by his estate, obviously. So they took the opportunity of his death to say, maybe we can get out of the contract. And the court says, you know what? At some point you had the opportunity to decide while he was alive, do we bring a duress claim? And at some point there, you decided, you know what, there's no point in us doing this, or we're not going to do this, and that decision should bind you to stop you from making a duress claim. Is the reason in the abstract. So that's a good illustration of, again, kind of that 3.5-year pharmacy care thing. You can also use McIntyre and Nemesis as an example. So, to summarize, with duress, you've got really three things that you want to focus on. One, what's the nature of the threat? Is it improper? Right? You can, I'll have to remove that, sorry, I'll remove that from the slides. Ignore the legitimate, illegitimate distinction, that's not that helpful. But just basically you're asking, is the threat improper? Second, were they coerced by the threat or pressure? Is there a significant causal link between the threat and their entry into the contract? Not the only link, but a significant one. There may have been other reasons, but if this was a significant one, then you're fine. Then lastly, the effect, which is really a couple of things. One, they can have the contract declared void, but there's some uncertainty as to what happens if they can't make restitution. Cite Halpern, leave it at that. Residual uncertainty. And then also just clarify that have they affirmed it? Just if they haven't, then the contract can be declared void. And if it hasn't, if it has been affirmed, then they can't get that remedy. Now, importantly, we are not focusing on any monetary damages here, because duress as a common law action entitles you to have the contract declared void, and by virtue of that, any restitution that follows therefrom. It's not about damages. It's not a compensatory regime. That differs from undue influence and unconscionable conduct, because those two grounds are actions in what we call equity. You haven't done equity yet, so I'm not expecting you to know the difference, but very, very briefly, a common law ground says the claimant is entitled to their, or the plaintiff is entitled to their rights at law. So your damages, right? For breach of contract, you're entitled to that as law. You can't, deviate from that. That's your entitlement at law. In equity, the court has much more discretion to decide what is the appropriate outcome to do justice. And that really was the motivation behind these two strands of courts that developed in Britain, right? One strand was the courts of law, the other was the courts of equity. And the courts of equity said, you know what, actually the courts of law, not often, but sometimes they don't reach what we consider just outcomes. So we're going to give ourselves more leeway to be able to be more flexible and to decide what the outcome is. Now, those jurisdictions have been merged in New Zealand, and so oftentimes, the High Court will just hear these grounds claimed together. But if the ground of undue influence or unconscionable conduct is claimed, just be aware that there's much more flexibility around the remedy. Yes, it can be declared void, but then, as we'll see, the court can also grant equitable compensation or other orders as well. So that's one of the advantages of bringing the other grounds. But duress, you should still, if the fact pattern fits, then you should still raise duress. Cool. So that was duress. Obviously, quite an interesting, potentially full-on cause of action, but I hope that set of diagrams helps, clarify things. We will do a scenario now, but before we do, does anyone have any questions about duress? Or anything from last week? Yeah.
Can you just explain again the justification for why we give the party a choice to void the contract instead of just voiding it?
Yeah. So for the recording, the question is, we give the party a choice to void the contract, right? And the rationale is this, that like a wrong has been committed. We think a wrong has been committed when someone is threatened or coerced into entering a contract. Right? That's what the law tells us. But we don't want the law to say that contract is immediately void. Okay, we don't want that to be the rule, because that will create uncertainty in business. That will create allegations and counter-allegations of breach of contract. And then another party saying, no, the contract is not breached. It never existed. I have no obligations to you. Functionally, it would create a descent into anarchy and chaos. It seems to be the broad idea. So what the court says is, okay, we need to create a guardrail on this to say that if a party has been wronged by a threat imposed on them to enter into the contract, they deserve the right to decide what they want to do with that contract. Do they want to keep it going, or do they want to have it declared void? If they want to have it declared void, they must go to court, they must get that declaration, and that will be seems to be the approach. Okay? And that sort of links to this idea of the free will point on affirmation, right? It's to say that we want the court, we want the party to be able to have that option to say, do I want to go ahead with the contract, or do I not? Okay, and if I decide not to go ahead with it, then I should take some action to that effect. Now, it is possible, right, for you to, it's possible, I mean, it's not borne out in the cases, but it's possible for you to say, to write a letter or an email to the other side saying, this contract was procured by duress, it is void, and I am essentially exercising my right to have it considered void. Now, if the other party says, you know what, I agree, like the contract is void, that's a possible outcome. They could agree to that, but in practice, it's much more effective to have the court declare definitively, because that it's void, because there will be disputes arising. So why the court says that you have the choice is to put power back in the hands of the victim, to say, do you know what, we want to give you the choice. You want to go ahead with this contract? Do you think it's actually not a bad contract? Or do you want to have it declared void? Either one of those you can do, but we don't want to just immediately say that you are not entitled to anything under that contract because it's a contract procured by duress. So that seems to be the approach. Number one, certainty. Number two, to give power back to the other side in these disputes. Other questions about duress? All right. Well, let's move to this scenario then. And so I had some fun with this one. So during his university days, Justin tried marijuana. Now Justin is a successful medical doctor with his own GP practice in Avondale. His sister Esther runs an interior design company in Henderson. Business is tight for her as businesses have smaller interior design budgets these days. So Esther says to Justin, your clinic is looking worn down. Can I redo it? And Justin says, you know what? I don't need that because I need the clinic operational. I need to see patients, right? Esther says to him, that's a shame. You know what's also a shame? I'm sure the Medical Practitioners Board will not be happy to hear one of their brightest new doctors has a history of illicit drug use. I don't see why anyone else has to find out, do you? Justin agrees that Esther will redo the office for a fee of $10,000 in 4 weeks. Esther promptly spends $800 on what she needs for the job. A week before the job, Justin has a change of heart and tells Esther. Esther brings proceedings against Justin to enforce the agreement. And your job is to advise Justin as to his rights at common law. So Justin is your client. All right, let's break into groups. Take 5 minutes to discuss this, how you would approach the duress principles and apply them, and then we will reconvene and have a chat just before the break. Then we'll take a break. All right, let's reconvene just before we take a short break. Lots of interesting discussions. Keep them going relative to the notes. I will say as well, I have a collection of exam revision scenarios for you that are separate to these ones, which I will post after our final class in week 8, along with some. We'll go through briefly some revision tips. So you have plenty of material to help you prepare for the exam. So let's open it up. What do you guys think? How would we advise Justin as to his rights under common law? So the duress cause of action here. What do we think? Yes?
It looks like the principles 1 and 2 and 3, 4 should be pointing out to me because there's a improper pressure of threat, which is kind of similar to threat to inflict person for a crime.
Yep.
Does seem like it was positive to be the ones who enter into the contract before she said that.
Yep. Cool. So absolutely. So remember we always use the roadmap, right? So you've got threat, coercion, effect, right? That's your 3. Okay. So with the threat, the argument is that it's a threat to report him for illicit drug use in his medical school days, right? And that the argument is that that's an improper threat or pressure. And it seems causative because he didn't want to enter the contract beforehand, and then he has a change of heart. What else? How else? What else can we add to that, or different thoughts, different approaches? Yeah.
I would just add that the type of discussion is kind of different to that what we'd expect from a general commercial negotiation, which is why also a problem.
Yeah. So it's different, right? In a sense that you wouldn't expect that kind of threat or that kind of statement to be made in a general commercial negotiation. Other angles, approaches, yeah.
Does it matter that the one making the threat is his sister, and does he really believe she's gonna do that since it's they're really closely related?
Yeah, absolutely. So did you have a?
That was what I was going to say. Is there not that I agree or anything,
Yeah.
but is there some kind of, siblings say dumb shit to each other all the time?
Yeah, absolutely. You don't want to see my group chat with my brother and my sister. Yeah, no, you really. It's not inappropriate. It's just like you'll look at me in an entirely different light. But you're right. So the fact that they're siblings, right? Does that change things? What do others think? Does it change or impact your assessment of whether or not you think this is an improper threat or coercion or anything like that? What do we think? Yeah.
I think that maybe if it was the less money, like $100, $200, then that could change it. But I think the fact that it's $10,000 and it means that this person has to come on this job for 4 weeks, that you probably take it a lot more seriously than just simply writing.
Yeah, absolutely. So that's engaging with the facts, right? Because it's a valid argument to say that, you know what, if it's just $100 to do this, like replace a curtain, right? Like that's different to $10,000 to remodel your shop.
Can we say that the sibling falls on between the 3 and then every kind of speaks that take it seriously so that the sibling relationship is kind of not as significant?
So sorry, repeat that.
I was saying, can we use the significant causal link
Yep.
between the 3 and him agreeing?
Yeah.
Can we use that to say that the sibling relationship is it's not a joke or anything?
Oh, yeah. So you're saying that the fact that he took it so seriously would suggest that it's not a joke. Yeah, absolutely. So a lot of these things are the facts can meld across different elements, right? That's perfectly fine. So the argument, the valid argument would be to say that his change of heart indicates that he took that threat seriously, which would suggest that it was an improper threat. It wasn't just a joke. Other thoughts, approaches to this question?
I don't know because I'm not in the medical field, but would the medical practitioners board really be that strict on someone who's just tried marijuana once in university? I don't know.
Yeah.
No, I'm just genuinely.
And the thing is a good question. So the question for the recording is, would the medical practitioners board, or whatever their name is, I'm not actually sure, but would they care that much? Would it be that significant? And two important things. Number one, you are only expected to know what's on the facts, right? So I wouldn't expect you to have any extraneous knowledge about the medical field or anything. But number two, that's absolutely an argument you could make. You could say that the nature of what she's threatening to do is not of, it doesn't sort of meet that threshold of being improper. Well, it's inappropriate, certainly, but it doesn't meet that threat of occasioning a claim of duress. That there seems to be sort of a threshold that courts will, they won't just let everything go for duress. They want something a little bit more.
Could you analogize it to the threat to report a person for a crime in Hayes and Carter? Because it is essentially what she's doing.
Yeah, absolutely.
It's the same authorities, but it's the same duress that she's implying.
The threat to essentially report illegitimate conduct and have that conduct sanctioned, right? That's whether we talk about the state sanctioning it or a particular disciplinary body sanctioning it, right? That's the same thing. So absolutely, you can analogize it to that. Maybe one more. Anything on the effect, or any other points on the threat or coercion? One more, and then we'll take a break.
With regard to the $800, would I be correct in saying that Justin doesn't have to pay $800 back?
Yeah, so good question. So you'd probably raise the restitution point, right? Because restitution is about putting them in the position they were in before the contract started. Okay? So the job hasn't started yet, right? So Justin hasn't gotten any benefit out of it, but she's $800 out of pocket. So what potentially you'd say is, well, ordinarily Justin may be required to put her to reimburse her essentially. It's not clear though from Halpern. That requirement is now up in the air, and you would just need to say that restitutionary obligation is uncertain. It would depend on what the court says. Perfectly fine to leave it at that. All right, that was a great discussion, everyone. The notes will be up for that. Let's take a break now. Come back at 12:10, and we will start with undue influence, and we'll hopefully get through that today, and then finish unconscionable conduct on Wednesday.
Does the restitution having to give back something you've got, or in this instance, having to pay for something the other person?
Sorry. Absolutely. So she's got a benefit from that, right? So it's not like she's got unused pay. So expired paperwork that can't be used, right? Like, so that would probably come into the factor. Yeah. Yes. Well, it's only contentious insofar as the court seems to be importing a moral element to the duress claim. To say that if he's been the victim, right, of the duress, right, and that's an inappropriate piece of law. Why should he have to pay anything? They raise the question. They don't give the answer, but they say intuitively there's something that suggests he shouldn't have to pay, or at least pay everything. That seems to be what the court was saying. All it did was raise the question. We don't have an answer yet. And because it's the common law, we are sort of relying on UK developments as well as Australia. And obviously in New Zealand we haven't had that development yet, so there's no way, even though what the Supreme Court says is different, that would obviously take precedence. But yeah, so it's an unsatisfactory state of affairs. Well, no, it's not come up in New Zealand, but certainly, that was just dicta from the 1978. So yeah, this is weird sometimes what comes up and what doesn't come up. You know, so yeah. Oh, cool. Yes. Yes. Yeah. So they bring the claim, they want to break the court is saying that despite you saying you want to do it, I say that you didn't want to. That you actually want to change the contract. So logically speaking, the two options would be I have nothing now to do. There's a contract that I have. Do I continue? Do I not? If I continue, court doesn't even involve me. But if I don't want to continue, then I involve the court. But if I involve the court, then one of two things happen. Either I get my word, or I don't because they say that actually I just want to continue. And they infer that from my action. Maybe from what I said previously, but they just infer it. So yeah, he would say, well, yeah, he would say basically, that is justified. He could either. All right. Got several interesting questions during the break. That's good. It shows you're engaging with the material and you're engaging with how these things would apply, both in a law school context, but in practice as well. So that's a really good sign. I've always said I think you guys are incredibly bright and engaged, and you'll go on to make really good lawyers. So you're proving that. Now, undue influence, as I said, is one of two equitable grounds that, similar to duress, are designed to respond to situations where one party enters a contract due to some inappropriate circumstance. And undue influence is a slightly broader ground than duress, in that it does incorporate duress-like elements in terms of threats and coercion, but it's broadly about the exploitation of a relationship that involves a power imbalance. That's the core of undue influence, which you can probably tell from the name. It's about one party using the influence they have over the other party inappropriately or unduly. As in duress, where you have threats that are improper and statements statements that would ordinarily be made in commercial negotiations, then undue influence is about, has the relationship been exploited or abused or taken advantage of by one party against the other. It's kind of the broad idea, for the purpose of getting them to enter into a contract. Now, one of the manifestations of undue influence that is prime is getting someone to enter into a guarantee with a bank, like you get your elderly grandparents to enter into a guarantee with the bank for a loan to you. Okay, so that's one of the manifestations that also applies with unconscionable conduct. So we'll see how that plays out, but that's not the only manifestation. Really, any sort of contract and undue influence claim can be raised. So all you need is a relationship between the two parties. Now on the slide, I've put a prior statement of the law just for you to sort of get a sense of what this area of law is about. It's about taking advantage or unfair advantage or unconscientious use, etc. But contractors bonding and SNE is no longer the prime statement of the law. It's just an illustration of the feeling or the vibe of undue influence. The statement of the law is from a case called Royal Bank of Scotland and Ettridge from the UK House of Lords, which has subsequently been approved in New Zealand. Okay? So, really, I have set the entire paragraph 6 to 89 of this decision for your reading. I think it's beneficial for you to read that. It does set out the principles, and it's quite useful to read those in full. So I would recommend you to do that. But again, I'll give you the roadmap to undertaking an undue influence analysis. Okay, and then we'll apply that to the various fact scenarios that we see in the cases. Now let's look at that third point firstly, because the Lord Nichols says it's usually only likely to come up when in some respects the transaction was disadvantageous either from the outset or as matters turned out. Okay, so logically speaking, when you've got a contract that is particularly imbalanced against one party, right? Disadvantageous towards one party. Your spidey sense should start to tingle, and you should start to think, ooh, undue influence here maybe. And that really generally applies to unconscionable conduct or duress as well. So just be aware that that's kind of what the court is getting at. Now, what are the two types of undue influence? Undue influence is really, there's two types, okay? One is actual undue influence. Okay? And this is where on the facts there has been an actual manipulation or abuse of a relationship. Right? For the purposes of getting the victim to enter into the contract. So there is a considerable overlap with duress. Where the overlap, where they turn into separate causes of action is not clear, and you don't need to ascertain where that is. You just need to say they have a claim under duress, they may have a claim under actual undue influence as well. Perfectly fine. And we'll see what some examples of this are, but really a lot of our time will be we'll be focusing on the presumed undue influence. Okay? And really, the presumption of undue influence requires you to have a relationship of trust and confidence. And a transaction that requires an explanation. So what this does is it raises the presumption that the transaction was procured by undue influence. Right? And if evidence suggests there was no undue influence, then the court will find so. But if you can't lead evidence, then that presumption will stand. So that's the general approach that is outlined by Lord Nichols in Ettridge, and which has been approved in New Zealand. Okay? Now, usually, that second dot point there depends on the nature of the alleged undue influence, the personality of the parties. That's about if you can lead evidence of the undue influence. If you can lead evidence that this has actually caused someone to enter the contract, then that would usually be an evidentiary point here. Right? So if you can raise that, all good. But what the court has said is, if you can show those two things, that's enough to flip the burden of proof onto the other side. The perpetrator or alleged perpetrator now has to argue that actually the transaction was fair and reasonable. It wasn't procured by undue influence. The other party did enter into it of their free will. So we'll talk about what each of those requirements are. Now, importantly, there are some relationships that automatically get to this point here. And it's not, not this point here. Some relationships you have to prove that there's the relationship, right? You have to use the evidence and show there was trust and confidence. But some relationships you can just say it's a doctor-client, right? Of TNC. Doctor-client, guardian and ward, parent and child, trustee and beneficiary, lawyer and client, all of these relationships that in society we accept as having a sort of imbalanced hierarchy, right? One party is in power over the other. The court says you don't need to prove that the weaker party put trust and confidence in the stronger party. You don't. You can just say that it's that kind of relationship, and there will be an automatic presumption of influence. it's not clear whether that category is closed. For our purposes, you can just rely on what on the evidence, examples that Lord Nichols provided, and if it's not in that list, then try and prove from the evidence that there was a relationship of trust and confidence. Okay? So that's the first requirement, that the relationship must be one of trust and confidence. If you read the judgment carefully, you will see that Lord Nichols specifies that it's trust and confidence in the context of the victim's financial affairs, right? In relation to the management of the complainant's financial affairs. So does it mean that other trust and confidence is not required? Not necessarily. In subsequent New Zealand cases applying the Ettridge approach, the courts have seemed to just be happy with, is this a relationship of trust and confidence? So for our purposes, we can just stick with that. It doesn't need to be specifically about the person's financial affairs or their admin or their management, even though oftentimes it will be that. Okay? But as long as you can show that one party put trust and confidence in the other, and that the transaction called for an explanation, that will raise the presumption and therefore require the other party to disprove the allegation of undue influence. Now, what does it mean for a contract or to call for an explanation? Well, Lord Nichols helpfully or unhelpfully says something more is needed before the law reverses the burden of proof, something which calls for an explanation. When that something more is present, the greater the disadvantage to the vulnerable person, the more cogent must be the explanation before the presumption will be regarded as rebutted. So what this means is that the transaction must be strange enough, right? The transaction must be weird or out of the ordinary enough to make you think, do you know what? Why are they taking on this much burden? Why are they imposing upon themselves such obligations for little to no apparent gain? Makes no sense. And that's a factual analysis that you can come up with. Some of you may think this contract is perfectly fine. Others may think it raises that presumption. Again, that's perfectly normal, and you can argue that. There's no... you could get good marks either way. Okay? So it's up to you to argue that something more about this transaction is out of the ordinary, abnormal, strange, out of the custom of that particular type of contract, whatever, so as to require an explanation. Again, you're not saying there's undue influence here. All you're saying is, this is a weird contract. This is a weird transaction. It needs explanation. Because what this is doing is reversing the burden of proof, and it's saying to the other side, please explain. Please tell the court, why do you think this contract must be upheld? So that's really the approach, right? With actual undue influence, it's usually that there has been something on the facts, right? They have done something. The textbook gives a few examples here. A son prevailing upon his mentally alcoholic and mentally incapable mother for a guarantee, that's contractors bonding and SNE. Materially false impressions in the minds of the parents as to the extent and duration of the risks they would run in executing a charge over their home. So guarantees that the parents or grandparents give to the bank for a loan to the children. Nephew procuring the resignation of his aged aunt from the trust when the son was absent and on threat of a dispute affecting the trust having to go to court. A migrant being told by her rich fiancé that the marriage would not go ahead unless she signed a prenuptial agreement making very little financial provision for her. Okay, so These all may well constitute duress as well, particularly that last one. That's perfectly fine. I guess one of the differences would be usually these undue influence points occur in the context of a relationship that exists. There is relational capital that is there to be abused or manipulated or exploited. That's usually what happens, and in fact that occurs there. Okay, so the way to conceptualize the two is to say that actual undue influence seems to be a sub-cause of action that reflects when there has been an abuse or manipulation of a relationship to enter a contract. Whereas presumed undue influence doesn't necessarily require active manipulation or abuse or exploitation. It simply is a reflection of the stronger party's failure to protect the interests of the weaker party. So that if they can't say that the transaction was freely entered into, that it was appropriate and fair, all of those things, then the court will say, no, that is a contract procured by undue influence, which we then have the power to rescind, declare that it didn't exist, and impose the remedies we see fit as an equitable cause of action. So that's a way to think about the two sub-causes of action. And from a practice point, it is prudent to, where the facts lend themselves to it, to plead both, right? On an actual undue influence, you can just say, look, there was an abuse or manipulation of the relationship, this is the evidence for it. There's no like sub-elements, it's just the facts. And then the presumption is to say, well, there was a relationship of trust and confidence, there was a transaction that called for an explanation, and that transaction cannot be, or that presumption cannot be rebutted. So really, it's a strategic point that you would plead both where you can, and say that even if there wasn't actual undue influence, there was a presumption there that can't be rebutted. So what we're going to do is we're going to look and see how these principles have been applied in various cases. And the important thing to note is that Ettridge comes after many of these cases. And so Ettridge is the culmination or the clarification of a lot of principles that may not have been, exactly applied in the strict way that we are conceptualizing them now. But these principles are all still there. So that's kind of what I just want to highlight in case you're like, oh, they don't seem to be doing the difference between actual or presumption, or where's the trust and confidence? It's all there. It's just may not be in the form that we think it's there. So one case in New Zealand is Brozovitz and Brown. You've got two friends here, Brozovitz and Brown. And the wife of Brozovitz brings the claim because she was the administrator of her husband's estate. And the problem was that he had a problem with alcoholism and liver failure and all those kinds of things. And closer to the end of his life, he had transferred his entire estate to his friend, Mr. Brown. Okay? And it was a pretty valuable estate in terms of what he owned, and in terms of this was like a mortgage over a property, and the debtor was paying about 8% per annum, so it was quite a lucrative ongoing source of income. Brozovitz says you can have this entire mortgage for £108, which would have been a lot of money back in the day, but still, not a heap. I mean, maybe it was back in the day actually, but it was payable in monthly increments, and the mortgage passed to Brown after his death, and he had no other liability except to cover Brozovitz's funeral expenses from that mortgage. So he essentially got this valuable mortgage over this other property that someone was paying back essentially. Brozovitz's wife says, no, that actually belongs back with the estate because that transfer to you was procured by undue influence. You abused or manipulated or exploited your relationship with your friend to procure this transfer of property. So that was the allegation. Now, the court did say that both sides had received independent legal advice, so that box was presumably ticked. But importantly, it was not determinative because there was a grossly inadequate consideration. So the court says, well, £108 just not enough, right, for the estate. It was grossly inadequate. The husband was in a very bad state of health, was unlikely to live more than a few years at most. Brown was a very close friend. The feeble condition and progressive decline in health was visible even to the casual observer, and habits of alcoholic excess were a matter of public knowledge. And the transaction was grossly improvident for the husband. So the result of the transaction was he had deprived himself of all recourse to his capital, had obtained an income which was insufficient for him during his life, and had left his wife without any inheritance upon his death. So then, importantly here, the nature of the transaction being so imbalanced, so in favor of one side and against the other, meant that even if there was undue influence, right? Sorry, even if there was independent third-party advice, that will not that will not stop there being a claim of undue influence. Now, I hear the hackles of contractual freedom being raised at the moment. How dare the court intervene in the bargain between two sophisticated parties? The court is not here to judge the adequacy or adequacy or sufficiency? What's the peppercorn thing? The acorn thing? Adequacy. The court is not here to address the adequacy of consideration. I haven't taught formation, so I'm going off first year contract law. They teach contract law in first year when I went to law school. It's like the first paper that you do. It's quite full on. So you guys are getting I think an easier ride by doing it in part 2.5. But the court doesn't ordinarily address adequacy of consideration. Court says, if you want to sell your car for $1, you sell your car for $1. We are not interfering. There was consideration, right? So that's the starting point. But the court here says, where there's not merely an absence or inadequacy of consideration, but there's also a relationship of confidence, control, domination, influence, or other form of superiority, such as to render a reasonable presumption that the transaction was procured through unconscientious use, the law will make that presumption and require the grantee to support the transaction and rebut the presumption of its invalidity. In other words, if you have a transaction where it appears the consideration is inadequate and the relationship is one of reliance or domination or influence, so these are the precursors of trust and confidence, transaction requiring an explanation, then the court says, you know what, that opens the door for us to adjudicate the adequacy of consideration. So, again, our tension, remember, contractual regulation, contractual freedom. Here's another way the court gets in the door and says, you know what, we are going to say that this is an unfair arrangement between two parties. So I'm continuing to probe on that because I think it's good to sort of think critically that, actually, there are a whole bunch of ways in which the law does not conform to the notion of two sophisticated parties and the court not intervening. Right? So here's the precursor to presumption of undue influence. Okay? Now it's up to Brown, Mr. Brown, to rebut the presumption that it was indeed not entered into by an improper influence over Mr. Brozovic, that he did enter into it of his free will, right? That transaction is actually was procured fairly. There was nothing inappropriate about it. So, why was that presumption raised? Well, it was raised because he was 66 years old. He was separated from his wife and family. He was living by himself in a public house. No domestic care or guardianship. He's dying of alcoholism. His friend takes him to his appointments. He does chores around the house, involved in financial transactions. Not merely his friend, but also to some extent his trusted agent. Okay? So it's a question of that the relationship is one of trust and confidence. Okay? That has been proved by the facts. And so the transaction was one requiring an explanation. It was improvident enough, imbalanced enough to raise that presumption. And then the question is, can that be rebutted? And one of the principal pieces of evidence that is going to be raised to rebut the presumption is that independent advice was provided. So the victim or alleged victim received independent advice about the implications and the nature of the contract and the rights and obligations they would be taking on. And therefore, they've entered into it of their own free will and consent, being fully informed of everything they need to be informed of. That's the argument. Now, in this case, number one, Mr. Brozovitz was sober when he signed the transfer, so he's not under an impairment caused by alcohol. But the legal advice was not adequate. The legal advisor had not been given all the relevant facts, and he wasn't told, nor did he undertake. He wasn't told to do due diligence on the transaction, nor did he feel it necessary to undertake that. He simply gave advice to Mr. Brozovitz based on what he had been told by Mr. Brown's solicitors. And so this is a pretty common thing in commercial transactions. One party will say, look, you need to go get independent legal advice, okay, just to make sure that you're happy with this transaction. That's normal, that's appropriate, but here the advice provided was inadequate. Okay, he just gave hypothetical advice as to what would be the effects of this arrangement, and he didn't have all the facts to really comprehensively advise. So because the advice was inadequate, there was nothing else that could disprove the presumption. Nothing else that Mr. Brown could raise that the presumption would be disproved. And so the court says, you can't rebut the presumption, therefore the presumption is that the contract is procured by undue influence, therefore the transfer is declared void, and Mr. Brown has to execute a transfer of the mortgage back to the estate, Mrs. Brozovitz, and there's various financial accounting orders presumably to restore what had been unduly gained. So this case illustrates the trust and confidence requirement. It illustrates the transaction requiring an explanation requirement. And it also illustrates how rebuttal can happen and sometimes how it's not going to happen effectively. Because the independent advice that is given must be comprehensive enough to show that when that person entered into the contract, they were told everything they needed to be told. They were doing so of their free will. It was informed. It wasn't just a tick box. It wasn't just a box-ticking exercise. So Brozovitz and Brown says, don't just see they've had independent advice and then say, oh, that can rebut the presumption. No, you need to show why that independent advice shows the transaction was appropriately entered into. All good so far? Questions, thoughts? All right, now we've got a few other cases that illustrate this. And again, all these cases are there for you to use as examples. You can anchor your analysis by analogy to the facts in these cases. Obviously, you have to engage facts in scenarios and potential exam problems that you feel you feel are most appropriate, but these cases give you factual anchors or analogies you can use. So in Brocklehurst Estate, the question was, an old man gives shooting rights on his land to his friend without taking advice, and there was no undue influence there. There was no presumption because this was only a relationship of friendship, so there's no trust and confidence. If anything, it's probably the alleged victim who was the dominant one. ASB Bank in Harlech is an interesting one because who's heard of the phrase Bank of Mum and Dad in New Zealand? You've heard that, and you may make use of the Bank of Mum and Dad to secure your first home. Very common thing to be done in Australia and New Zealand. So that was an issue here. The parents provided a guarantee for a loan to their daughter and son-in-law, which was mortgaged over the parents' property. So in other words, if the daughter and the son-in-law failed to pay the bank back, the bank had a right to repossess the parents' house to recoup their losses. And that comes up trumps, or that the bank tries to enforce that guarantee, and the issue is, was it procured by undue influence? And the court says, no, it wasn't. The parents, there's nothing to suggest that the parents weren't, independent, that there was any greater trust and confidence they placed in the children that was normally present, and it was just an average family relationship, right? So this highlights a couple of important things. Number one, remember the Ettridge categories, the automatic ones, right? Lord Nichols said parent and child is an automatic presumption of trust and confidence, right? ASB Bank and Harlech seems to suggest that Lord Ettridge meant, that kind of parent and under 18 child, where there's that hierarchical relationship of trust, where the child trusts the parent. It's flipped in this instance, right? Because the relationship between parent and child that's being alleged is the child has exercised undue influence over the parents to procure the loan. So if that's the case, then you need to prove that there was trust and confidence. You can't just assume. Okay, so that's just a sort of first point. And the second one is that you need something more for trust and confidence. You can't just have a regular relationship where, anybody's parents rely on them for tech support at home. Yep. I've had experience with that. My mom laughs at that, and now that I'm out of the country, so my brother is the one. He's now married, so it might be my sister now. So yeah, but parents, that's not enough. You need something more to suggest that it's the kind of relationship of trust and confidence that would occasion a presumption of undue influence. Okay, there's something more. Can't just be an ordinary relationship. And the last one is public trust in Otto. In that case, you had the public trust, and the husband and wife received a loan from the public trust. They both guaranteed the loan personally, and what that means is that the creditor, public trust, could go after each of them, not just both of them together, like each of their individual assets if the loan fell through, the payments fell through. Now, that falls through, and the wife says, I was coerced or unduly influenced to enter into this contract by my husband. And the court says, no, that's not true. She was going to benefit from the loans to live in various properties, and the loan was clearly for the benefit of her and her family. So in that case, that's an illustration of this one, the transaction requiring an explanation. Right? If the transaction is not like that bad for you, or in fact it actually benefits you, then really that's not going to raise the presumption. You need something that's pretty bad for you, that disadvantages you significantly out of the ordinary to sort of raise that presumption. So these cases really suggest that you need something more to raise the presumption. You need it can't just be kind of ordinary commercial transactions. And also, you need more than just independent advice. Brozovic kind of already told us that. You need sufficient independent legal advice. And what's curious is that undue influence can apply to gifts as well as contracts for which there was, consideration. So one of the situations is, imagine like nursing homes, right? Some of you may have grandparents in nursing homes, and the nurses there are obviously going to be very, involved in the care of the occupants. And so one of the problems that can occur is because of that attachment, right? It's just a platonic attachment, but the occupant will say, "Oh, I want to give my money to my nurse." Who's seen the movie Knives Out? Anyone? You seen Knives Out? Okay. That's an illustration of that kind of thing. That wrecked my flow. So that's an illustration of that kind of. I won't spoil Knives Out for others who want to watch it. I would highly recommend that movie. But that's an illustration of that kind of thing, where a gift is made. I'm not spoiling it. A gift is made, and the question is that procured by undue influence? And the entire movie is actually about that. So this case, Inchinoria, gives us some sort of guidance as to kind of what that, how do you rebut it in the case of a gift. The free exercise of independent will, you need to establish that the gift was made after the nature and effect of the transaction had been fully explained to the donor by some independent and qualified person, so completely as to satisfy the court that the donor was acting independently of any influence of the donee and with full appreciation of what they were doing. And in cases where there are no other circumstances, this may be the only means by which the donee can rebut the presumption. Okay, now that statement is in the context of gifts, but it can be instructive for other contracts with consideration as well. Right, so what can we take from this? Number one, fully explained to the donor by some independent and qualified person. Okay, so independent advice. Let's just say fully explained. So the transaction you can't be partially explain it, you need to look at the whole transaction, right? Qualified person. Doesn't necessarily have to be a lawyer, but it's a qualified person, an accountant or an auditor or something like that. That is qualified in those circumstances. And that it was explained that they were acting independently. So they were no longer under the influence, or they were not under the influence of the donee, the person who's going to receive the donation, and with the full appreciation of what they were doing. So they fully understood the implications of their actions. So that's a statement made about gifts. It's not immediately directly applicable to contracts with consideration, but it can be persuasive, and that's a good way to think about it. So for our purposes, you're welcome to use this and say, this is a statement about gifts, but the principles about independent advice are still likely to be broadly applicable to assessing whether or not independent advice meets the threshold for rebutting the presumption. Okay? And then lastly, it's not enough to say that, well, I didn't actively abuse it. They just decided to give me all this stuff, or, all my estate or anything like that. If the presumption is raised, You have to rebut it by assuring the court that they did it of their own free will, that they were fully aware of the consequences, all of those things. If you can't show that, it's not enough to say that, well, I just didn't profit from it. I didn't do anything. And that's one of the differences between these two grounds and duress. Duress typically requires the defendant to have done something, made a threat, acted in an inappropriate way. It's a positive action. Whereas unconscionable conduct and undue influence can cover omissions, failures to act, and receiving benefits from those failures. That's one of the differences. Now we have 5 minutes left, so what I'm going to do is talk you through this case because this is an excellent, possibly I think the most excellent illustration in recent years in New Zealand of both undue influence and unconscionable conduct. So I'll talk you through this, and then before I do, I just want to highlight this set of principles here. Okay, so these principles are taken from the textbook. They're called suretyship, but they just mean guarantee. And you can cite them as principles from Ettridge. Now, all they do is they tell you how do you apply undue influence principles to situations involving three parties, where party A exerts undue influence over party B so that party B enters into an agreement with party C. Right? Now, typically this involves the provision of a guarantee so that party C will provide the loan, party B will provide the guarantee, right? And they will have a contract. There will be the undue influence. Okay, so that's typically the arrangement. The overarching idea of these principles is that the undue influence here can be imputed to C, the bank, such that this guarantee can be rescinded. So if you can impute the relationship, the undue influence to the bank, principally by the bank failing to check or ensure that the guarantor is entering into it of their own free will, that kind of thing, then the bank can be essentially penalized and not able to enforce the guarantee. So there are various principles here which I'll leave you to read, but that's the overarching idea. You can cite them as Ettridge. And actually what I'm going to do instead of going through Whaagutu now is I'll ask you, I don't ask this often of you, but if you could read that case before Wednesday. I know, revolutionary. Oh God. Just one case. Can we do one case? Just one. Read it, and I'll test out my Socratic teaching method of calling out to ask what happened in this case, or what do you think? But I wanted to raise it as a discussion because it's a good introduction to undue influence as well. Okay? Very briefly, before we go, affirmation also applies to undue influence. So if the contract is procured by undue influence, a third-party purchaser, then it can't be voided. Okay? And it can't be. That's for third parties. If it's affirmed, then it can't be voided. So that's the first thing. So very similar principles. You can just cite Olcott and Skinner for that. Public trust and Otto is the illustration of that, where they take this. It's very similar principles, taking a longer time. And there's a third-party protection as well. So very similar to the cancellation kind of third-party principles, protections. That's all set out here. But you need to be a third-party purchaser, so you need to have paid something for for what you got from that contract. And you need to get it without notice of the undue influence. So you need to be not aware that there's something inappropriate here, because otherwise you can be on the hook. All right. So file Gutu for Wednesday. I'll see you then, and we'll get into finish undue influence, get into unconscionable conduct.